Welcome everyone. Thank you for joining us this morning. I'm Nikki Jovicic from Lookupstrata and I'm very happy to welcome our panellists today. Joining us, we have Tim Graham, partner from Bugden Allen Graham Lawyers. Today we are discussing everything Victorian strata. When referring to legislation, Tim will be specifically speaking about Victorian legislation. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. Thank you to all of the people who submitted questions leading up to the event. We'll be addressing these in just a little while, but first, Tim has a presentation for you on how to alter your plan of subdivision. I'm delighted to introduce our panellists today. Tim Graham, partner for Bugden Allen Graham Lawyers. After more than a decade as a partner of HWL Ebsworth Lawyers, Australia's largest independent law firm, Tim joined the partnership of Bugden Allen Graham Lawyers in June 2021, his name being added to the firm's brand. Tim is one of Australia's preeminent strata lawyers and is internationally renowned. He is president of the Australian College of Strata Lawyers and a fellow of the college. Tim is also a council member of Strata Community Australia National and Strata Community Australia Victoria. He sits on the Property Law Committee of the Law Institute of Victoria. Tim has been recognised by his peers and numerous local and international awards, including Best Lawyers in Australia 6 times and in the Doyle's Guide as a leading property and real estate lawyer and leading litigation and dispute resolution lawyer. Tim is a keen educator and presenter, having conducted more than 300 seminars for strata managers, real estate companies, industry associates, banks, insurers, brokers, and legal CPD providers. He has guest lectured at RMIT, Deakin University and the University of New South Wales. Tim has recently joined the advisory committee for RMIT's Strata Community Management course. Tim is published regularly in the Australian Property Law Bulletin and is a member of the Bulletin's editorial panel. He authors the Owners Corporation chapter of the Law's Practice Manual and wrote the case study updated for subdivisions with the lot. Tim's also a regular contributor to the Lookupstrata blog. Tim runs the Victorian office of Bugden Allen Graham Lawyers. Tim, I'll pass the session over to you now to share your screen and tell us all about altering a plan of subdivision.
Nikki, thank you kindly for that warm introduction. Good morning, registrants. So the blur for this session was that you don't need a unanimous resolution and it's easier than you think. Those are fair comments. It's not to say that it's an easy process per se, it's just easier than you might think. And there are ways to circumvent the prima facie unanimous resolution requirements. So we're going to work through that. And there's been a little bit of a meandering of the case law, and in the specific case of entitlements and liabilities, we've got some amending legislation coming in December. So I'll traverse those in the presentation. The first threshold question when posed with the proposition of amending a plan is a unanimous resolution required? There are certain amendments that do not require a unanimous resolution or indeed consent of the owner's corporation at all. If your plan of subdivision is a staged plan of subdivision, then the procedure in section 37 of the Subdivision Act applies, and the owner of the staged lot can cause a suite of changes that are identified in section 37 to occur without any consent or authority of the owner's corporation whatsoever. This paper is concerned with amending a plan. Let's assume it's not a staged plan, and it can be done by unanimous resolution in any of those ways. They're set out in section 32 of the Subdivision Act. Mercifully, I will refrain from reading through them verbatim, but when you look at it, the owner's corporation, if authorised unanimously, can do almost anything by way of amending the plan, including there's an interesting one there, dissolve itself. And I'm going to, one of my case examples is going to look at dissolution of an owner's corporation. It's only happened once in Victoria, to my knowledge. but I've got a couple that are at various stages where that's aspired to take place. If a unanimous resolution is not sought or obtained, the tribunal has the power to order that a plan is amended. Seeking a unanimous resolution and failing is not a necessary prerequisite to going to VCAT, although because the tribunal is required to be convinced that it should exercise the discretion to amend the plan, one of the questions it will inevitably ask is, why is there no unanimous resolution? Was it sought, etc.? So I think usually in the course of things, you will seek the unanimous resolution firstly, but certainly I've run cases in VCAT seeking amendments to plans without first going to unanimous resolution. One was a land swap at a property in the southeast suburbs, of which at that time there were over 800 lots. And it was just futile to seek unanimous resolution out of 800. The most I've seen in 23 years of doing this, off the top of my head, I think is 10. So unanimous resolutions, as we know, are difficult to procure. And I guess that's one of the fundamental tenets of this paper, because they're so difficult to elicit. How do we get around it? Well, we go to section 34 capital D of the Subdivision Act, and it immediately presents us with two alternatives. And historically, they have been regarded as just that, alternatives, although there's a decision which is only about 2 months old, which has qualified that, and I'll come to that towards the end of this component. The first is 34D1A, and all that says is that notwithstanding a unanimous resolution has not passed, the tribunal can order that a plan's amended. 1B says something different. It says that the tribunal can order that non-consenting parties to an amendment are deemed to have consented. Now, they're expressed at a glance in the legislation as alternative, and that poses a question. I should add that if you go under 1B, there's a whole lot of attendant statutory criteria. You need 50% in favour. You need evidence as to why voters have either not voted or have voted against the resolution, and you need to establish that the proposed amendment is in the social and economic best interest of the owners corporation. None of that applies to 1A. So the shortest way home has typically been to just go under 1A and avoid the criteria in 1B. It's exactly what happened in this 2010 decision of Bugden and Kung. What happened was that it was a moribund commercial owners corporation on Heatherton Road in South Springvale, and it had an expansive asphalt car park, and Aldi came along and said, we want to build a store on the car park, so we want to acquire that part of common property from the owners corporation. It offered $1 million consideration to do that, as well as various other improvement works around the scheme. And the application of VCAT was made under 1B. So the owners corporation had to establish all of those statutory criteria, including the social and economic best interest test. The economic one was pretty easy. Aldi had offered the $1 million plus additionals. That was clearly in the economic best interest to revive and give impetus to this otherwise struggling owners corporation in Springvale. The social one was an interesting one on the evidence. There was one objector to this, which was a church within the scheme, and the reverend gave evidence on oath that was found to be unreliable. So that's going to be a question for or a conversation for him and his piety another day. But anyway, the tribunal found that it was in the social and economic best interest for this amendment to occur, and it was done. The landmark case was a couple of years later. It was involved this property at 29 Gibbs Street in Richmond, and it was an entitlement and liability question. What happened was that the owners corporation proceeded under 1A. It didn't plead 1B in the alternative. And that lot owner, who was going to have to pay more money and was going to lose voting power, brought an application that the owners corporation had proceeded irregularly and that the proceedings should be dismissed. And the matter went before the president of VIC at the time, who's on a justice guard, and he made these findings that 1A and 1B are completely independent. 1A isn't subject to 1B. 1B doesn't take primacy over 1A. So there was nothing in the way the proceeding, the proceeding had been brought that was irregular. So that was great. That gave us a very clear footprint to just proceed under 1A and ignore all the statutory criteria in 1B. Unfortunately, that we've been brought back down to earth on that appeal decision earlier this year. I'll come to. Just before I do, entitlements and liabilities are often the harbinger of these disputes. People are always looking to increase their voting power, or probably more particularly the corollary to save more money. It's something I think that's done very well in Victoria to in that we recognise that entitlements and liabilities are two different propositions. Other states don't have this. Entitlement is based purely on value, and that makes sense because in the event of a total insurance loss and a cash settlement, money is dispersed according to entitlement. So that makes sense, but liability has nothing to do with that. Liability is the way to replenish the resources of an owner's corporation to the extent to which an owner has had recourse to them. So Section 33 sets out, you'll notice the preface in both of those subsections, if the owner's corporation makes any change. Unfortunately, those don't require, those requirements don't apply inaugurally when plans are first registered. But if a change is to be made, and that includes registration of a stage in a stage development, regard must be had to those two sections. Back to our Richmond Gibbs Street case. The case was successful, and I just want to draw your registrants' attention to the second last bullet points there, because one of the arguments oftentimes, and it was explicit argument in Conroy's case, that the developer, that owner that objected said, I knew that I was buying a significant voting power and a minimal financial contribution. That was one of my incentives in purchasing in the first place. Oftentimes parties would probably be a little bit more robust in expressing that sort of cognition, but that was the position, and the court said that it was irrelevant. It doesn't matter what you buy into, it doesn't matter what you thought you're buying into, because the legislation provides these vehicles for change. It is necessarily flexible and subject to change, and therefore what is in the subjective mind of the purchaser is not a relevant consideration in the tribunal determining whether or not to amend a plan. While we're on entitlements and liabilities, so it's a really good way. The tribunal, if it's satisfied that the schedules are right, will have little hesitation in ordering their amendment. And this is a really good case study where that begs, I'm hoping for instructions one of these days, but it begs for an amendment, because what we had here is a property in Trinity Crescent, Abbotsford, and you'll see the major parcel there marked NIS. That means not in subdivision, because the lot above it, which is A, it was originally a stage lot within the plan, but it was registered as a separate subdivision. And when that occurred, the developer, you might just notice on Trinity Crescent, about halfway along there, there's a tiny little spliced out parcel marked S3. Well, the developer gave himself for S3 about 70% voting power. So 100 lots between them had about 30% voting power. And this silly little parcel, which if you're walking along the footpath would be indistinguishable from the footpath, it's just a little curve. That's where 70% voting power, 100 lots get 30%. That's going to be upset by the tribunal. Obviously, it's just not fair, it's not right, and Section 33 has not been complied with when setting those. My circle's gone a little bit awry on this slide, but this slide goes to some of the inventive ways that a plan might be registered. It's not always to fix problems. It might be for some commercial improvement. And what we had here in McMahon's case was McMahon's own lots 801 and 802, blue chip building on St Kilda Road, Melbourne, fantastic vistas over Albert Park and Port Phillip Bay. And they wanted to knock out the common property wall between those two lots, and that's where my circle should sit. That was common property, and so what they required to get rid of that wall and consolidate those two lots into one lot was a transfer of that part of common property heretofore comprised of that wall, and the tribunal ordered that occurred, that they didn't have to pay for it, although it had a notional value attached. It wasn't as if it was a part of common property on which someone could read a book or eat a sandwich. So the social and economic best interest arguments are the way that these cases are usually fought. But here it was a little bit of a corollary to that. It was more, it couldn't be said that it was in any other lot owner's social and economic best interest for this amendment to take place. But so the corollary argument was run that it didn't adversely affect anyone else, that the only people that had really use and enjoyment of that part of common property were the owners of 801 and 802. They benefited from its transfer. No one else did, but that was good enough to convince the tribunal. That's been done a few times. Moving really swiftly between the 1B and 1A dichotomy, this Latrobe Valley case was an excision. There's lots there you might see. I think they're marked street addresses 48 and 50 or somewhere down there on the right hand. Oops, my apology. On the right hand end near Lydiard Street, the lot sought to excise itself from the plan, and they went under 1B only. And the tribunal wasn't satisfied that the social and economic best interest test had been made out, but there seemed to be this implied inference in the judgment that had they have proceeded under 1B, they would have been successful. We then had O'Gorman's case. So O'Gorman was barrister, and she pleaded 1A and 1B in the alternative. But what the tribunal did here, and I think that was wrong as a matter of law, and I think it was certainly contrary to Justice Gard's comments in Conroy, was that 1B criteria was applied to 1A. Strictly speaking, that is not proper process, but substantively, we might end up in about the same place because of this decision, which is the one I threatened to speak to, and it's out of Real Estate Victoria, and it was an appeal decision in June this year, and that's upset the apple cart a bit because that stands for the proposition that 1A and 1B are not alternative, that that they are to be read conjunctively, that is cumulatively, and for VCAT to make these orders, you need to satisfy both 1A and 1B criteria. The first sentence there is probably the trigger that the tribunal can't require. You can get orders under 1A all you like, but registration of the amendment won't occur unless there's an order under 1B as well. So that's the current state of play. All of the learnings, I've spent 15 minutes going through a history that some of which is rendered somewhat nugatory by this decision, that this is the tip, and that probably the main takeaway from this morning is if you're bringing these, you really need to address 1A and 1B criteria now as a result of that decision. Just one or two more cases before questions. In other ways that plans can be amended usefully. This is Echoville, which is out in the western suburbs of Melbourne, and that's the dream that was sold by the developer to off the plan purchasers. A beautiful amphitheatre, and the birds are warbling gently in the deciduous treetops. This is what they actually got. It's really quite shocking that it's a place where certain gangs have seen fit to reconnoitre and indulge in their clandestine, nefarious activities. And the Owners Corporation has just spent good money after bad trying to maintain this area. Security was futile. what happened was that they then did a deal with the developer that they'll transfer this part of common property to the developer, divested of it. There was two parts of common property. There was this amphitheatre and there was a little strip at the front. The strip at the front went to council. This area was sold pursuant to an order. The order had a threshold sum of $2.something million, and if the owners corporation got an offer that met that threshold, then pursuant to a 34D order, the disposition of that parcel was ordered, and the owners corporation was then dissolved. This is an estate. It's not where there was common property or shared services that justified the need for an owners corporation without these common properties. So it's the first and only dissolution by order of an owners corporation. Some of the questions will no doubt go to this last man standing issue, where we've got 7 out of 8 people agreeing to sell and 1 person holding on. If the tribunal, in this case, the tribunal can order the dissolution of the owners corporation, but didn't ever affect anyone's title in their lot. But sometimes if you've got this last man standing situation, the order that an owners corporation is dissolved, does that mean and include that the tribunal has the power to effectively deregister someone as an owner? We're arguing that. I've got a case before the tribunal, and I go all the way to British Columbia as some authority for the proposition. Now, these cases were both to do with rule breaches, so they arise in vastly different circumstances, and they are quite legislation specific. But the learning is this: when you look at the powers given to the British Columbian Tribunal, they appear immediately identical to the powers that the VCAT Act gives VCAT. And if, no matter how you get there, if the ultimate result of the tribunal having a power in British Columbia meant and included the power to kick someone out of their lot, in those cases as a result of persistent rule breaches, then we're going to apply that to the power to kick someone out of their lot as a result of effectively a dissolution or a collective sale of the owners corporation. So watch this space. This is my last slide, and I think I'll be about right on time. Just in regards to, we looked at amending entitlements and liabilities earlier, and under section 33 of the Subdivision Act, entitlements based on value, liabilities based on just and equitable contribution to the general and admin expenses of the owners corporation. Now, I made the point that there is no immediate or inaugurally, when the plan is first registered, those tests don't apply. What we've got pursuant to the Owners Corporations and Other Acts Amendment Act 21, which comes into operation on the 1st of December, it's a few short months away now. We've got these new tests put in that do apply inaugurally, and that lot liability must, so it creates a presumption. The starting point is that lot liability is equal unless, and then if there's a substantial difference in the size or consumption or maintenance obligations, then it may be proper to have differential lot liabilities, but the starting point is that they're identical. And entitlement, it says the same thing. Well, what I think the entitlement, there is one variable word in that didn't appear in section 33, and that's the word market value. So entitlement's still based on value, but now it's said to be market value. And I'm not sure that that's right. I mean, I understand it, and it's probably easier than trying to quantify reinstatement and replacement value. But on my example of an insurance payout in the event of a total loss, you're really looking at reinstatement replacement value, not market value. So anyway, I commend the fact that we've been given some clarity around the type of value that we're supposed to apply. I'm just not sure that they got that value right. Thank you kindly for your generous attention, Nikki. That concludes my pre-prepared slides, and I'd be happy to deal with any questions.
Excellent. Thanks so much, Tim. If I can just get you to unshare. Yeah, fantastic. Thank you. That was great. That was really quick. Wonderful. That was really great information, quite detailed. It's great that you got some information in there on the end about the changes that are coming up towards the end of the year as well. I'm sure everyone's really interested in seeing how that will pan out. Now, we did have some questions come in, and thank you to the people who submitted them. And as we discussed quickly before the webinar, it's a really great way to apply the information that you've just spoke about into some real life examples, and I'm sure that will help everybody. And then I'm sure we'll have questions. We've had a few come in already, so I'll try and keep up with those as well, and we'll see how we go. But if you're ready now, we might just jump into the first question.
Yeah, please.
Okay, so this one was from Michael. I own a unit in a block of 8. There is a block of land at the end which is owned by our block. The land is worth about 200,000, so each owner's stake is 25,000. 7 owners would like to sell the block, but every time the matter is raised, one owner votes no. She owns the unit next to the block and has moved her fence in order to use some of the block for her garden. She doesn't want anything built next to her. Is a vote of 7 out of 8 enough to be able to sell? Can we force her to move her fence back to its original position?
Well, I think 2 things arise out of that. One is the plan amendment, and the other is the notion of this fence. Dealing with those separately, factually, it sounds very much like our Button and Kung or the Aldi example, where most owners want to sell, one person doesn't. This isn't a circumstance where they lose title. I imagine that this parcel is common property that can be carved out and disposed of. It very much looks like it's that Aldi example then. So if you get a fair purchase price, the tribunal would require some evidence that that the sale value has some relationship with proper realisable value. That would deal with the economic best interest. As far as the social best interest goes, well, I suppose that sole lot owners' arguments are going to be they're probably more planning arguments, such as overshadowing, overlooking, and the proximity of any construction that might occur. Those would have to be balanced out. So I mean, that case, like every case, will come down to evidence about what the proper value is and what other amenity type issues there are. But it looks pretty similar to that Aldi example on its general principles. In regards to the fence, it's of course common where owners abutting parts of common property see them as their fiefdom, and that they can use them, as their own, and fence them off, etc. Well, it's a plain breach of the rules, the model rules. Whether or not your owner's corporation has registered rules, I don't know, but you probably don't need them. The model rules make it clear that an owner or occupier must not obstruct other owners and occupiers or lawful interests from their ability to access common property. So that fence can be removed apropos a rule breach.
Okay, wonderful, thanks. All right, we'll move to the next one. This one's from Charles. I own an apartment in a complex in suburban Melbourne comprising of around 100 units spread over 2 buildings. The block is made up of a ground floor and 3 floors above. Each apartment has a deck. All of the owners assumed they owned their deck when they purchased their apartment. The complex is not quite 8 years old. Problems were identified with the design and construction of the decks a few years ago after occupation. In dealing with the builder and developer to get compensation to rebuild the decks, it's become clear the decks are common property as the boundary is in a face on the post, and the original surveyor says this was intentional to ensure all the decks looked the same. What would be involved in changing the ownership of the decks to part of the title for each apartment?
I think it's the same question. Well, what's involved? The process. The process is this: if you're seeking unanimous resolution or you're going to VIC asking for an order that a plan's amended, you need to obviously produce the amended plan and say, well, this is what we've got currently, and there needs to be a juxtaposition in what's called a Section 32 amended plan of subdivision. So the pretty easy step on what's involved as a preliminary to everything discussed this morning is to get a Section 32 plan prepared, and all that does is state where the boundary lies. So you get that prepared, and then you seek your unanimous resolution, or alternatively you go to VIC and you seek an order that the plan is amended in accordance with the draft Section 32 plan proposed. As far as the default position on, I noted that it was an interior face boundary, and it seems to me that on interior faces, your post is probably common property. I heard reference to that. There was no reference to the tiles and membrane. If you'll indulge me for about 30 seconds, I think it's just important to note when we're talking about balconies on interior face plans that tiles and membranes are part of the lot. They're not part of common property. There was always arguments. I've been having this argument for 23 years that the boundary must be read from the structural part of the balcony, which is going to be the bearers and the joists, etc. The stuff that lies above that, the elements being the tiles, the screeds, and the membrane, it's not structural. You don't see it in structural engineering drawings. It doesn't have load bearing capacity. You see it. You see tiles in off the plan contracts in schedules of fittings and finishes. And why distinguish between a balcony tile on the one hand as compared to a kitchen or a bathroom tile on the other? No one ever seriously says that the OC should replace their kitchen tile. Maybe they have. I haven't seen it. But for some reason, when it comes to balconies, there's always this notion that tiles and membranes are owners' corporation property. Well, I've been saying for all that time they're not. It took a long time, but there's two cases out of VCAT. You've got to be careful not to say them too quickly together, because one's called Fisher and one's called Munger. But Fisher and Munger both stand for the proposition that tiles and membranes are indeed private property on interior face plans.
Okay, and we do see lots of questions around that too, Tim, come on the site, so I can fully understand how you feel there. Okay, all right. Next one, after an OC has voted unanimously to alter the plan of subdivision, usually by way of removing a lot owner from the plan of subdivision, the relevant owner then engages a solicitor and surveyor to undertake the necessary works in order to alter the plan of subdivision. Is there a role for owners corporation managers in this process?
That's a good question. I suppose the role of a manager in the process is the same as the role of a manager in all things pertinent to owners corporations. I'd tackle the question this way. Your contract of appointment, certainly if you're using the standard form SCA, but in any event, the contract of appointment unlikely says that it's a manager's duty to have custody of this or to curate this process for an annual fee. But it's the sort of thing where an experienced manager and the ability to understand propositions like the differential contribution to the general administrative expenses and the procedures generally of VCAT and the titles office. I think managers have a very important part to play in curating this process. It's not part of your annual fee, though. I imagine that it's something that it's an additional service. In other words, Schedule 2.2 in the standard SCA contract of appointment would enable a manager to assist with the implementation of this amendment and to be paid for it quite appropriately. So I think the manager's based just on the experience, he certainly has a part to play in assisting the implementation of it. I just need to be very clear that I don't think that's part of the standard fees, so it should be regarded as an additional service.
Okay, great, thank you. Okay, we have one here from Lee. We purchased off the plan. We feel that our lot entitlement is too high compared to other lot owners that have larger lot areas on the plan of subdivision. What can be done to address this?
Yeah, well, if it's wrong, it's wrong. The way to as it stands, we're pretty clear that entitlement is based on value and liability is based on a just and equitable contribution to the OC's expenses. I noted the question about size, and I think size is not directly relevant to value or consumption. It's indirectly relevant to both. Obviously, when you're looking at when valuers are calculating a value, size is one of the many things they'll take into account, but it's not the only determinative. And the same in terms of the relationship between size and consumption. Well, I suppose the bigger the lot, the more people that it might accommodate, and the more people there are, the more consumption there may be. But you could give extreme examples that just go the complete wrong way. You might have a hole in the wall coffee shop at ground level, as compared to a penthouse that takes up a whole floor plate at the top. The penthouse might be really occupied, and all of the waste and the services and water and utilities and these sorts of things are going to be disproportionately highly consumed by that retail enterprise at the bottom. So you've got to be very careful looking at size. So I've just taken the size, I've extrapolated the size quotient of that question because I thought those comments were important to make. But as far as the more direct, what can you do? Well, it's a question of, I should also say that valuations are going to be subject to value, to valuations by valuers. These cases, whether you're going to VCAT or you're seeking a robust and maximising the prospect of unanimous resolution passing, you're probably going to need some pretty good evidence. So for entitlement based on value, its evaluation is pretty clear. For liability based on consumption, it's something that typically surveyors have done. I've used surveyors as experts in all of those cases we've discussed this morning, and their evidence has largely been accepted. So what can be done? Well, I think it's a matter of getting an expert opinion about what the actual consumption is. You obviously, there's a little bit of a forensic arithmetical exercise in that, but at the end of the day, I think what you want to do is get an opinion as to whether as to what the consumption is, and if the opinion agrees with your own that you're paying an inequitable amount, well, you've got robust evidence then to apply to VCAT for an order that the plans change and that the schedule of lot liabilities is amended to reflect proper consumption.
Excellent. And will that be affected at all by the changes you mentioned at the end of the presentation, Tim, moving forward?
Sorry, Nikki, could you just repeat the very first part of that question?
Sorry, you mentioned at the end of your presentation that there will be changes that are affecting that coming up with, and somebody did ask actually when the changes are coming into effect, and I believe it's the 1st of December this year, is that right?
Yeah, okay, that's right.
So that answers that part of the question, but will your answer change with the changes that are coming in with the new legislation at all? Or
but I think we've already identified in terms of lot entitlement, we've now got the word market value, where previously it was just value. So I think that is something to be careful of, that if you're getting valuations to change entitlement, make sure you're getting a market valuation, because that's what the legislation is going to say from the 1st of December. In regards to liability, I'm not sure it'll be that different. I think you've still got, it's still a question of consumption. You've got the presumption that's going to be imposed that everybody has the same, unless, and then it goes into the extent to which owners consume the utilities and the size and whatever. So I think you're perhaps coming it from the other way, but you still, you only unpackage it sort of one layer, and you still find yourself in a situation where it's a test about, should these things be identical? Should the presumption be departed from that lot liabilities are identical, having regard to all of these matters? And I think when you get to the substance of what's a fair contribution for each lot to pay vis-a-vis each other lot, then it's probably not going to be too much different. But I say that in the vacuum. The amendments aren't in yet, and oftentimes, it takes a little while for them to bed down. And, as you get decisions, as we've seen on the way that the law has meandered in these cases, we're in a progressively better position to advise on things like that. But to me, it looks more cosmetic than substantive, if I can wrap it up as neatly as that.
Okay, thank you. Thank you for addressing that, Tim. All right, we've got one coming in from Monica. I'm looking at purchasing an apartment that is detached from the main block with no apartments above. I was wondering if the roof is part of the lot or common property, as I would like to build a loft or rooftop terrace to improve its value.
I couldn't answer that without seeing the plan. There's no sort of generic fallback position. The key would be in the plan of subdivision. That might be one, Nikki, that can be dealt with through your publication offline. I'd be delighted to do that. But yeah, there's no ubiquitous answer to that question.
Okay, thank you. If the OC wants to divide the plan of subdivision, can one OC hand over ownership of a section of common property to make the split possible? If this is the only thing binding the two OCs together, what other factors will VCAT require other than an unanimous resolution?
Well, that's they're mutually exclusive VCAT and unanimous resolutions. You either get your unanimous resolution, in which case you avoid the pleasantries of VCAT, or you go to VCAT because you don't have a unanimous resolution. It's pretty much one or the other. But to get the amendment registered, you do need one or the other. And certainly when we looked at one of my early slides, I know it was a long time ago with a whole lot of detail, but it set out, you might remember, pretty much verbatim, the various amendments to plans that can be made under Section 32, and those included disposing of common property or acquiring common property. So it seems, as I've understood the question, it seems that if there's two owners corporations involved, that there would need to be mutual unanimous resolutions. It reminds me of an interesting one where, and this question sort of comes up a lot, where if you've got a limited owners corporation, can it, for example, unanimously resolve to change some part of, for example, limited common property without reference to the unlimited? As a matter of law, I'm yet to be convinced that it cannot. But I can tell you that the registrar of titles will not amend. And I mean, if you've got a unanimous resolution from OC 10, good example, there's a building I had again on Security Road, one of the leading buildings there, and there was one story, consisted of two lots, and those two lots were members of a limited owners corporation and the only members. And that limited owners corporation had a limited common property, which was the lift well. So that owner, like we saw in McMahon's case, wanted to consolidate its two lots into one lot, but it also, McMahon's case was to do with the wall. In the instant case, it would have required a transfer of the lift and foyer into private property. So unsurprisingly, the limited owners corporation, one lot owner, unanimously resolved for that transfer. And the titles office wouldn't register it. It said that it needed OC1's unanimous resolution also. That is the unlimited's unanimous resolution also. The reason for that probably is when you look at Section 30 of the Subdivision Act, and it says that limited OCs vest in the unlimited OC. In other words, the unlimited OC owns the limited OCs. But it really doesn't reconcile with the proposition that limited OCs themselves are separate legal entities. If you go to the Owners Corporations Act, other than in the definition, which have just been adopted from the Subdivision Act anyway, there is no reference anywhere to limited and unlimited owners corporations in the OC Act. In other words, if there is a duty or a function or a power or an obligation or a right imposed or conferred by the Owners Corporations Act on an owners corporation, then that applies to an owners corporation, whether it's limited or unlimited. The Act does not distinguish between them. They're separate entities. And therefore, notwithstanding that OC 10 might be owned by OC 1 by operation of Section 30 of the Subdivision Act, it's still a separate entity. And as a separate entity, it's that owners corporation that's the proprietor of common property 10, and it's that owners corporation that would unanimously resolve to transfer. So I'm not sure the Registrar of Titles has got that right. It's going to take a serious challenge to the Supreme Court or beyond, I think, to cause a change in the customary approach of the Registrar of Titles. Maybe the author of this question might be the guinea pig. So someone has to be at some point. But that's probably about the best I can do, given the status quo of things. There's a legal answer to it, and there's a practical answer.
Okay, and sometimes there just isn't answers to these questions in Strata, is there, Tim? There's not
Yeah, indeed.
Okay, and we did have another one coming, which I might read out. It was to do with a building that had 9 different owners corporations, and we've actually had a similar question. So the one that was submitted was from Bob, and we've had a similar comment come in from Regina as well, that the answer might cover both. And it was to do with, we have over 1,200 apartment lots, 22 retail, 5 office lots spread over 4 varying sizes towers. There are 9 owners corporations in total. We have got a list of them all, but I won't read through them all. But could it be viable to combine some of the owners corporations? If this can be done, can there be an agreement or license within the owners corporation to limit some sections to certain parts of the common property? We currently pay for our OC manager for 9 OCs and a building manager limited after hours assistant for 7 OCs. So we're looking for a way to lower levies. My thinking is the title changes could be costly to reconfigure the OC makeup. This question's come about because a neighbour was in Queensland a few months ago and came across one site that had multiple towers and various common facilities, and the agent told him that the apartment had only 1 OC and access costs were allocated and charged via an agreement dependent on the facility access required.
It's hard to be too specific on that level of detail without seeing a plan. I'm going to have to sort of stick on general principle. But it's quite possible. I think surveyors, whether of their own motion or whether under express instruction from developers at inauguration of developments, sometimes do some crazy things. And sometimes it might not be so crazy. It might be crazy sort of with today's litmus. The nature of things change, and and it wouldn't be unknown for, as different permitted uses under retail leases change or whatever, for something that might have looked and worked fine operationally at the outset because of the fabric and the stage of development and potentially who the tenants were, etc. It just might not be the case 10 or 20 years down the track. There might be very good reasons. It might have been rendered outdated, is my point. So I think that there is a lot of benefit, and certainly in big complexes, to have health checks on have we got the most efficient and economic operationally owners corporation structure. These things, both of my partners, Gary Bugden and Michael Allen, both do a stack of work in rectifying, I suppose, plans that were just set up badly in the first place. And it's certainly something that I think would warrant a closer look. I don't think I can be any more specific on or the specificity of that particular plan without sort of looking and understanding its detail. But I'm empathising with the general proposition that there might be a whole lot of inefficiency created by a structure that maybe it was doing it far from the start, maybe just with the affluction of time it's become outdated. That it can happen either way. And sometimes surveyors just do bizarre things. I don't know if Peter Davies is part of our audience today. Peter's a council member of SCA VIC that many of you will know. And Peter, I'll thank him, drew my attention many years ago to an owners corporation in Jolimont. And my numbers won't be exact, but they'll be close enough. There's 72 lots, for example, and 71 owners corporations. It's a short-term accommodation proposition, and from memory, Peter did send me the plan once upon a time, but I think that there was, you know how you might have sort of a general hallway in a hotel, and there might be a little sort of step off from which there's two doors, two rooms might be accessed from a little step off. Well, each one of those was a limited owners corporation. Was a limited common property belonging to a limited owners corporation. So we had 72 hotel rooms with 71 owners corporations. That's just crazy. I shouldn't make light of that term. That is injudicious, and that is a surveyor that or developer that are a little bit loose and unhinged, I think, at the time that was prepared. Those sort of things, I would have thought the tribunal is going to have very little trouble indeed dissolving all of those superfluous, unnecessary owners corporations. So I'm sorry I couldn't do better with the specifics of the question, but there's just too much detail in it to deal with, I think, on this basis. But I applaud you for your motivation's sound. I applaud you and commend you for recognising that there might be a better way to do things, and I encourage you to get proper advices with a view to potentially doing that.
And is there a better time to go through an audit type process like that, Tim, with the new changes coming up at the end of the year? Like, will that trigger some people to take a closer look at what's happening with their building? I know in other states, when the changes have come through, it's triggered a bylaw consolidation and those type of things. So is that a good time to kind of look at things and see how things are happening in the scheme, or it doesn't really make that much difference?
It probably doesn't make a great deal of difference, and I don't want to be unhelpful, but I can think of one amendment coming in that might encourage people to do nothing. And I'll put that this. I often present when we're talking about amending plans, inevitably entitlements and liabilities are a significant element of that discussion, and I often present it in the way that we've got the so-called benefit principle here in Victoria, that lot that benefits more pays more for extraordinary items of expenditure. It's a band-aid add-on. It's a divergence from the rule that fees are paid in accordance with liability, and its implementation has proven, capricious and subjective and problematic, and continues to do so. I often present, when we're talking about amending, doing a health check on your plan and amending entitlements and liabilities, I often do so pro and antecedent discussion about the benefit principle, because it's often used in these sort of circumstances. You've got a manager or a committee or whomever sitting there going, look, this just doesn't look right. I'm going to sort of fiddle with it a little bit and change the apportionment, whatever. You can't really do it. The benefit principle is really narrow. It relates to repair and maintenance, other works carried out wholly or substantially for some or one of the lots, and not all of the lots. And in that event, the lot that benefits more might be required to pay more. But repair and maintenance is your starting point. If the cost doesn't to do with repair and maintenance, the benefit principle doesn't get you anywhere. So rather than fumbling around trying to apportion costs on an equitable basis, if the problem is more of a deep-rooted one, it's a question of amending the schedule of lot entitlements and not, lot liabilities. It's not a question of trying to shoehorn in the benefit principle to every expenditure that comes your way. That's my foundation comment. The reason why I say, Nikki, in direct answer to your question, that the 1st of December amendments might cause OCs to be less inclined about monitoring the health of their schemes is we've got this new sort of benefit principle that's going to be introduced, certainly in regards to insurance costs, but also repair and maintenance costs. The OC is now given an almost statutory licence I'm overstating it, but something of a statutory license to levy fees as it sees fit. And if it can do that, it can completely disregard the schedule of liability in the plan. It really disincentivizes getting the liability schedule right. That's not my view. I think that the plan is primary and paramount and should be respected as such. And that's the more holistic way to deal with differential expenditure issues. But it might be an unforeseen, unintended consequence of the amendment that we can ignore the plan and just do what we want because the amendment permits us to.
Okay, well, we'll have to see how that one pans out come the end of the year, I guess.
Yeah.
Okay, and we've just got, I think we're just on time at the moment, but have you got time for just one more question maybe? We might just jump into one more before we finish.
Yeah, more than that. Yeah, of course. Sure.
Okay, this one's from Richard. Is there any way to have liabilities changed without having 100% agreement? Have we covered this one, do you think? Or?
Yeah. But I think, if I can just extrapolate a small part of it, you don't have to. We've been using the terms entitlements and liabilities collectively. I congratulated the Victorian Parliament early on for distinguishing between the two, and then I've proceeded to basically package them together. They don't have to be dealt with separately. You might, for example, unanimously seek to resolve or apply to VCAT to change only the lot entitlement or the lot liability. You're not necessarily having to do both. So I've just taken that question. I've fashioned the fact that it referred to lot liability only. I've taken that part of it and said I think it's a good question because it makes it clear to us that we can just make an application or unanimously resolve in regards to liability. We don't need to do entitlement contemporaneously.
Okay, great, thank you. And VJ's just put one last comment up, so I might just jump into that quickly to finish off. Any thoughts of multi-stage developments at the completion? Can common areas be consolidated along with OCs if there is no need of exclusive use for a given stage? Does that?
If I've understood that correctly, the answer is probably yes. It sounds, VJ, like it's a stage plan. Section 37 of the Subdivision Act applies to it, and on the registration of additional stages, Section 37 gives a whole lot of license to do all sorts of things. I think that answers your question, but it has to be, of course, also consistent with the originally approved master plan. So there's a couple of checks, but on those sort of things, there's a lot of flexibility to do almost anything on the registration of each further or subsequent stage.
Okay, wonderful. Thanks very much. Well, we might leave it there, Tim. And so thanks very much for today. That brings us to the end of the session. If we did have a question that was submitted and we didn't get to that, then please feel free to jump on our site and resubmit the question under our Ask a Strata question page. I did try and keep up with them as I was going, so hopefully we've got them in there and we might be able to run those past you, Tim, and get back to people if that's okay.
We'll probably have some good content for your publication foreseeably, Nikki. I look forward to it.
Excellent. Thank you so much. And we'll let you know when that's done. So keep an eye out for the presentation that Tim shared this morning and also the recording coming out to you later today. And I'd just like to say a very big thank you to you, Tim, for your time today. Really wonderful information. And I'm sure everybody got lots and lots of information out of it. We've got some great comments coming through.
I appreciate the opportunity and thanks everybody for your generous attention.
Okay, and right at the end, we always ask our presenters if you've got anything that you'd like to share with us, some really great news. Obviously, the great news is you joining Bugden Allen Graham Lawyers. That was fantastic earlier this year, but anything to do with that or any other information you'd like to share with us at this point?
I know that Bugden Allen was one of 4 property law firms recognised, won awards for the best boutiques in Australia. Given that I've only been there 2 months, I thought it was improper to place any stake or claim any credit for that. But I'd just like to wish those teams in New South and Queensland congratulations, very well done for that deserved accolade, and yeah, we look forward to growing together.
Excellent. Congratulations on that award. That's fantastic. And we obviously work with Bugden Allen Graham up in New South Wales and Queensland as well. So yeah, really great to hear that news. All right, well, thank you so much, everyone. Keep an eye out for regular publications that we send out that will let you know what's happening and when we're having regular webinars and other events around Australia for our national audience. And we'll no doubt see you soon. Thanks very much, Tim.
Thanks so much, Nikki. Thanks, everybody.
Bye.
Bye now.